Hello and welcome. My name is Devlin Hartline, and I'm legal fellow at the Hudson Institute's Forum for Intellectual Property in Washington, D.C. We have a fantastic panel lined up for you today to discuss copyright protection in the digital age. With the advent of the internet, it's given consumers more legal choices than ever to enjoy copyrighted content online. But it's also created numerous challenges for copyright owners, both in the United States and abroad. Copyright owners find themselves playing a game of whack-a-mole, where infringing content reappears faster than it is taken down. Copyright law has always evolved as technology evolves, and the internet has been no exception. But balancing the various interests at stake, consumers, copyright owners, and internet platforms, has proven both difficult and contentious. Congress enacted the Digital Millennium Copyright Act, or DMCA, in 1998 in order to balance these interests. And part of that legislation created various safe harbors that give some legal certainty to all involved. However, copyright owners, both big and small, have complained that the safe harbors are not working as intended. And a recent report by the US Copyright Office has agreed. Many copyright owners are now advocating for the use of technology to combat the infringements that technology itself has exacerbated. And that's what we'll be discussing today. In particular, we will look at the use of filtering to capture infringements in real time, for example, when content is uploaded. And we will look at site blocking to close off pirate sites from the rest of the internet. We have a wonderful group of expert panelists to dive into these issues. We have Stephen Tepp. He's the president and CEO of Sentinel Worldwide and a professorial lecturer at George Washington Law. Steve is an expert on copyright law and policy, and he'll start by discussing his new policy memo for the Hudson Institute on filtering and site blocking. We have Michael D. Smith. He's a professor of information technology and marketing at Carnegie Mellon University. Mike will discuss his empirical research on the efficacy of site blocking. And we have Vance Ikazoya. He's the CEO of Audible Magic. Vance will discuss Audible Magic's content recognition technology and his experience both here in the United States and abroad. I'm very thankful for everyone taking time out to be here with us today. And we'll start with opening remarks by the panelists, and then we'll move to a moderated Q&A. And with that, I'll turn it over to Steve Tepp.
Thanks very much, Devlin, and thanks to the Hudson Institute for this event and for its continuing interest in effective intellectual property. I'd like to note that my remarks are my own and do not necessarily represent the views of any client or employer. Business models and technology have changed dramatically since the 1990s, nowhere more so than online. Those changes, along with some key judicial decisions, have distorted the operation of Section 512, the US copyright law provision specifically designed to address online copyright infringement. Today, even a platform that knows 80% of what it hosts are unlicensed copyrighted works can be shielded from accountability by the safe harbors in Section 512. A system that not only permits but rewards such scofflaw behavior cannot be allowed to stand any longer. Copyright owners are left to send millions or even billions of takedown requests with little actual effect on piracy. This, along with other factors, led the US Copyright Office to conclude that the cooperative environment the law was meant to create has not and will not be realized without amending the law. And while dozens of other countries have successfully adopted measures to address online infringement from beyond their borders, the United States has not acted to implement similar procedures. The practical reality of online infringement is that while hosting platforms may portray themselves as neutral, it is a foreseeable near certainty that users will post infringements on those platforms. These infringements draw audiences, which in turn allow the platforms to profit by collecting user data and pushing out paid advertisements. This profit incentive for platforms must be countered with legal incentives to address piracy effectively if balance and cooperation is to be reached. Indeed, the current environment has created a significant preference for one set of business models over another. When right holders seek to negotiate a license with platforms, their leverage to refuse a license is diluted by the reality of an ineffective enforcement system. Everyone knows that the platforms will have these works on their networks one way or another. So the platforms can offer below market rates, and right holders have a choice between taking those crumbs or getting nothing at all. Restoring the balance needed to address online piracy effectively and provide an incentive for platforms to cooperate with copyright owners should include 3 key steps. 1, amending the law to reverse harmful judicial decisions, most significantly to restore the red flag test for when platforms should have to act on apparent infringement. 2, requiring appropriate filtering out of infringements at the time of attempted upload. And 3, codifying the authority of federal courts to order the blocking of foreign sites dedicated to infringing activities. That said, it would be a mistake to treat all internet platforms as the same. There are a variety of business models and a variety of approaches to dealing with piracy and other unlawful postings. We should also not make the mistake of assuming that platforms of the future will look like those of today. To the greatest extent possible, the law should seek technological neutrality. A properly calibrated system of addressing online piracy should also consider the legitimate interests of independent creators who use internet platforms as their primary or exclusive method of reaching their audience. The spectrum of those interests are not accurately represented by the polemics too often heard in copyright policy debates, nor are they an excuse to keep an inefficient and malfunctioning system in place. The rights of copyright owners must be respected and practicably enforceable, and the entire system should continue to promote the production and distribution of creative works. At the same time, a platform that complies with filtering obligations in good faith should not be punished for missing the mark on a close call. The Copyright Office provided a roadmap for course correction regarding misguided judicial decisions, and platforms already commonly use both filtering and site blocking tools to protect their business models and reputation. The objection to using those same tools in a copyright context ring hollow and should not prevent consideration of measured and appropriate rules to reduce piracy. Thank you.
All right, thank you, Steve. Mike, you're up next.
Thanks, Devlin, and I want to thank you and your team for organizing this session. I think this is an incredibly important question, and I'm very happy to participate. I'm the empiricist on the panel, so most of the research I do is related to looking at what the data say about how piracy impacts 3 key questions. So first of all, does piracy hurt producers? Second, does piracy hurt consumers? And then third, and the focus, what we're going to talk about today, can government regulation help reverse some of those harms? So I do work at Carnegie Mellon University with my colleague Rahul Talang. We co-direct a center called the Initiative for Digital Entertainment Analytics. And over the past 10 years, we've examined each of those questions, along with many colleagues in our community. So let me start with the first question. The first question is, does piracy hurt producers? Or said another way, does piracy hurt sales? And there are a bunch of creative theories you can come up with for why piracy might not hurt sales. And a lot of people talk about those theories. When you look at the data, however, there's a broad consensus in the academic literature that piracy does exactly what you'd expect it to do. It causes people who otherwise would have paid for the material to get it through illegal channels. This is the conclusion of a review of the literature we wrote for the US Patent and Trademark Office last year, where we looked at all of the peer-reviewed studies that had addressed this question. And what we found is that 29 of the 33 peer-reviewed studies that looked at whether piracy harms sales found a statistically significant and economically significant harm from piracy, that piracy caused to producers. And again, these are different authors using different methods, studying different contexts. all coming to the same conclusion. The next question is, does piracy hurt consumers? Now, why might piracy hurt consumers, right? They're getting something for free, surely that's great. Well, the reason piracy might hurt consumers is because of everything we know about economic incentives, which is if I'm a producer and I can make less money by creating this content, I'm probably going to have fewer economic incentives to invest in this content. What do we see in the data? That's exactly what we see in the data. So we have two papers that look at this. One is a paper my colleague Rahul wrote that looked at investment in movies in Bollywood in the mid to late 80s, around the time the VCR made it easier to pirate Bollywood content. And what he found, again, in a paper published in a peer-reviewed journal, is that when it became harder for Bollywood studios to make money, they invested in fewer projects, and the projects they invested in actually had lower quality as measured by their IMDb rating. My colleague Brett Danaher and I have a similar paper published in the George Mason University Law Review that looks at this in the context of international countries. And what we find is that after piracy was introduced, countries with higher levels of piracy ended up having fewer movies created that were of the caliber that got them nominated for Academy Awards. Okay, so this is bad for producers. This is bad for consumers. Third question, is there anything we can do to help? Is there anything government regulation can do to help? And we've looked at this in a variety of contexts. We looked at this in the context of notice sending in France, where the French government sending notices out to known pirates increased legal music sales by between 22 to 25%. We also studied the shutdown of Mega Upload and found that when Mega Upload was shut down, legal digital movie sales increased by 6 to 10%. The two particular ones that I think are most relevant and interesting for today is we've looked at this in the context of Google search results. And what we find is that when you move pirated content from the first page of Google search results to the second page of search results, you see a significant decrease in the consumption of piracy and a significant increase in the likelihood of purchasing legal, not just among a general set of consumers, but also among consumers who initially introduced a search term that indicated an interest in piracy. So even the people who start off saying, find free streaming of this movie, were more likely to consume legally. The one I want to spend a little bit more time on is we have a paper looking at site blocking in the UK. So the UK government has instituted a program where known pirate sites that are adjudicated by the courts are required to be blocked by ISPs. In this study, which again is published in a peer-reviewed academic journal, we looked at 3 waves of blocking. In the first wave of blocking, only the Pirate Bay was blocked. And what we found is that when only the Pirate Bay was blocked, there wasn't much change in piracy and there wasn't much change in legal consumption. People shifted to other known pirate sites and increased their use of VPNs. However, in 2013, when the UK government simultaneously blocked 19 sites, and then in 2014, when they simultaneously blocked 53 sites, we saw a big increase to the tune of 7 to 12% increase in subscriptions to legal streaming sites and to consumption in other legal channels. In short, and this is getting to Devlin's whack-a-mole analogy, in short, the game of whack-a-mole is never required you to hit all the moles. The game, to score points in the game, you just have to hit enough moles. And what we find in our study is that by making it just a little bit harder for people to consume piracy, you can actually bring more people into legal channels. Thank you again.
All right, that's great. Thanks, Mike. Vance, you're up.
Well, again, thank you for hosting this. Let me just talk a little bit about what we do, and I know when we get into the more detailed conversation, I think this definition of piracy needs some more discussion. So what Audible Magic does is that we are a technology service provider. Our core technology is we have audio and video identification technology, matching technology that can be used to match an unknown piece of content with registered copyrighted content. So our majority customer are the digital platforms, especially around social media. And what we do with how they use us is they integrate us at the point of upload, some of what you guys have been discussing, and we check that content before it gets posted to those platforms. And we check it to see whether it contains copyrighted music or film or television works. Then we notify the company in real time, and then the social media company generally blocks it and notifies the uploader that it's containing copyrighted works. Initially, the technology and the system was used to identify unauthorized distribution, piracy, and were used as primarily a blocking tool, because many of our customer platforms do not want the copyrighted content to be distributed. But increasingly, there's been some more nuance to that, and platforms and frankly, copyright holders want to be able to specify business rules, whether it should be blocked, where it should be allowed on all platforms, or whether it should be tracked for licensing and monetization purposes. And I think increasingly we're seeing that both platforms and rights holders are choosing that third category of licensing and monetization. The benefit for this is it gives some flexibility to rights holders. You're an independent, small, undiscovered artist. You want your content to be out and in the wild to build an audience, where there may be other major rights holders who have content that they want to protect. And so we have that capability of providing that flexibility. The way we work with rights holders is we offer the service to register your content for free along with your business rules. And then we charge the platforms for the service. So we're kind of unusual, and the platforms are actually paying for this capability themselves. Our customer list includes Facebook, Instagram, Twitch, SoundCloud, Dailymotion, Roblox, ShareChat in India, DistroKid, The Orchard, so a number of both distribution players as well as digital consumer platforms. Just to give you a sense of the scale of social media, we process about over 5 billion queries a month of content being checked for copyright. And at our peak, we could be checking 7,500 a second. That gives you a sense for the scale of user-generated content in social media. So that's just a little of the background. We have international, global customers. We have big customers. We have little customers. And I think in general, our customers and the market have found that technology can be used to address a certain aspect of this problem.
All right, thank you, Vance. I love it. You guys are all talking about solutions to the piracy problem, right? So Steve talked about the knowledge standards under the DMCA, particularly red flag knowledge. If we put more of the burden on the say the Google search engines of the world, then maybe they wouldn't list the Pirate Bay in the search results. and as Mike discussed, even if you just downrank them, which Google does, but if you downrank them, then you have less piracy. If you block more and more sites, you have less piracy. And what Vance is talking about, filtering at the time of upload, we can prevent these things from being posted at all, or perhaps even better, it creates new licensing opportunities for the copyright owner, so they could allow it to go up and they could monetize it somehow. And so before we talk about these solutions to the piracy problem, I think it's important to talk about what is the scope of the piracy problem. How big of a problem is piracy? And I think if you ask different people, you'd probably get different answers. And so I'm going to throw it out to you guys. How do we define the scope of the problem in the first place?
Go ahead, Vance.
Well, I was just going to say, this is a part of the conversation. I think the definition of piracy it should be clarified partly because back in the day when when Audible Magic was first starting, piracy was very obvious and clear. It was whole files and whole movies being uploaded to these sites or peer-to-peer downloading services and completely being substitutional, frankly, to commercial use. At least on the social media side, copyright use has evolved from those whole entire works to small clips of works, scenes of movies or 10-second bits of music being utilized in a consumer their own video. So at least what we see is that evolution has changed, which both challenges the technology, but then I also think starts to bring up the topic of, at what point is this classical piracy? One comment, though, is that across social media, of those over 5 billion files that we see, we get about match rates in the 4-5% range to matches to copyrighted content. So that might give you some sense on traditional social media, the amount of copyrighted content use.
Yeah, Devlin, I can speak to this in the context of traditional movie piracy. And we've got several papers that are able to create a counterfactual world of what would happen if you could eliminate all piracy. So one paper I'm working on with a really good recent graduate of Carnegie Mellon, it looks at this, and what he finds is that if you were able to eliminate piracy in the theatrical window, theatrical sales would go up by something like 15%. And if you could eliminate it in the home entertainment window, home entertainment sales would go up by something like 20%. Now, what does that mean in practice? I think what that means in practice is if you think about these as risky investments for the studios, there are probably a whole bunch of movies where you could take 15 to 20% off the top and it would still be profitable to make. But there are going to be a lot of projects where if you take 15 to 20% off the top, it's no longer profitable to make, and those projects aren't going to get made anymore. And I think that's, as someone who loves creative art, that's kind of scary, that we've created a world where now it's no longer profitable for some artists who might have a movie that is a niche piece of content or doesn't have the broad appeal of an Avengers Endgame, isn't going to get made anymore. I think that's something we should care about, both for the good of the studios, but also just for the good of society and creativity in general.
Yeah, thank you for that. And I agree. I mean, I love blockbuster movies, and I will take my boys and we'll see every Marvel movie that ever comes out to the end of time. But yeah, you're not going to get the art house movies and things like that, if it's too risky because of piracy. And to Vance's point, I think it's a great point. Generally, when I think of piracy, I think of wholesale copying, right? You're putting the entire work online for free. It gets a little trickier when you're putting in clips or something where they might have a claim of fair use. And so I think that's a topic that we'll circle back to in a little bit. So my next question for you guys is why is there so much resistance to the idea of using filtering and site blocking? I know in Steve's policy memo, he mentions that filtering is already a fact of life, and site blocking too, with certain websites that with viruses or spam or things like that already get filtered out. So we're already using filtering, we're already using site blocking. And already under US law, it's possible to get an injunction against the website and get it shut down. But it's not as formalized as probably it could be. But we hear from the other side that this stuff is going to break the internet. And it seems to me, well, the internet's not broken, even though we're doing it already. So why is there so much resistance to incorporating these things into law?
I guess I could jump in on that. I think first, as I've mentioned, it is broadly used today in a number of platforms, and some of the major platforms, US and globally, already to identify copyright. I also think, though, that the arguments against filtering that are used, especially in the policy side, tend to stem from a lack of understanding of what the technology actually does. And I think they think about, yeah, the internet police and censorship, and that all comes up. But if you really could come down and understand the basics of the technology, that it just doesn't work that way. It's not like we read and watch every movie or upload and we make judgments about, you know, whether this, what movie or what music or song this is. So I think it stems from that and the complexity basically of the technology. And I think it's hard for on the policy side to have that kind of understanding. And so that those arguments are used as a, you know, a blanket. You don't even want to go down that path because suddenly we're into you know, 1984.
I completely agree with Vance. I think a big part of this problem is it's tough to get the details of how the technology actually works out there. And so people tend to settle on the sound bites. You know, this is going to break the internet. What we know in the UK is that they filter websites and the internet seems to be working just fine. The other thing we also know about any law is it's going to have pluses and minuses. The one I think a lot about is I'm required to wear a seatbelt when I drive. I can imagine that there are probably certain situations where you get in an accident and you might have a greater amount of harm because you're wearing a seatbelt. But those represent a tiny fraction of overall accidents. We don't say, wow, this is going to cause some harm that wouldn't have otherwise occurred. Therefore, we weigh the advantages against the disadvantages. And I think when you calmly and rationally weigh the advantages and the disadvantages here, what you conclude is we ought to give these platforms stronger incentives to protect to protect rights holders and their content.
And I want to pick up on that word incentives, because to me, that's really what it all boils down to. You look at the evidence that was presented in the Viacom versus YouTube case, which involved copyright infringement by YouTube in its origins. And it was very clear that the founders of YouTube understood that they were hosting 80%, they said it in their own internal emails, 80% of what's on our system is infringing. And yet they let it go. And they understood that the way the law works right now, unless there's a specific complaint against a specific file with a specific spot site, they don't have to do anything. And not only don't they have to do anything, they're rewarded with the protection of the immunities in Section 512. So, look, not every platform is built on infringement the way the YouTube founders did it. And YouTube is very different today in how it operates. But there is still some question of profit incentive, even for platforms we think of as being perfectly legitimate, because piracy draws eyeballs, and those audiences, those eyeballs, give the platforms data to collect and people to whom they can provide paid advertising, and that's how they make their money. So what Vance described in terms of both the partial uses in social media and the preferences for copyright owners and platforms to reach a point where everyone's getting paid for the uses, that's the goal. That's the goal. The reality is the law is in the way of that goal right now. And that's the biggest problem. And despite the fact that social media uses by their nature are going to be shorter clips and that sort of thing, that goes to audiovisual works and to musical works and sound recordings. But if you're a graphic artist, a photographer, your entire work is an image. And so that's commonly infringed online, both on social media and on other types of platforms. And very often, those creators are small businesses or independent creators without the same sort of resources for enforcement that the law has placed on the copyright owner right now. And even the large scale copyright owners don't find the notice and takedown system to be an effective tool. So we need the law to simply come back to a place of balance to promote the sort of cooperation and mutual ability to profit that Vance is describing.
Devlin, if I could expand just briefly on what Steve just says, I think the issue around incentives is absolutely critical here. My colleague, Marshall Van Alstyne, and I had a piece in the Harvard Business Review a couple of weeks ago talking about Section 230. And one of the things we mentioned in that piece is that the Senate investigation of a site called Backpage used emails to show that Backpage knew full well that underage victims were being sold for sex on their site. They just didn't have the economic incentives to do anything, to do enough about it, because they knew they were immunized by Section 230. Similar argument you can make about Pornhub. Pornhub knows that they're underage victims on their site. They just don't have the economic incentives to do anything about that. That really needs to change.
Well, yeah, and whether you're talking about Section 230 or Section 512 of the DMCA, we're talking about user uploaded content, and in Backpages, all the incentives were there to not do anything about it, and we have the same problem as Steve has discussed, with YouTube at the beginning. It was all about piracy, and so I liked what you said earlier, Mike, about how we should sit down and talk about this calmly and rationally. But I've been in DC long enough now that I don't think that happens nearly enough, right? So there's a lot of slogans, break the internet. So another one that we hear frequently is that internet platforms shouldn't be the copyright police, right? And so this gets to the balance issue, right? And so what we're trying to balance, there's at least three things we're trying to balance as I see it. There's the interests of consumers, there's the rights of copyright owners, and then there's the internet platforms themselves. And so a constant topic of debate is who should have the burden. And so as Steve discussed earlier, what Congress intended was for there to be cooperation between copyright owners and internet platforms. And I think after 20-something years after the DMCA, I think we can say assuredly that this cooperation hasn't happened probably as much as it could or should. But so my question to you guys is, what do you say to people who say that it should be the content owners, it should be the copyright owners who have the burden of policing their own copyrighted works online? Why are we putting this burden or any burden on the internet platforms themselves? Is that fair?
So I'll jump in on that, Devlin, thanks. And that is one of the core questions at the heart of the policy debate here. And it was one that was debated before Section 512 was written into law. I was working on the Hill back at the time when some of the early versions of that legislation were floating around. And it was a genuine question. Who's in the best position to prevent or reduce this type of activity? Who is the least cost avoider? And on the one hand, the platforms control their own systems. And so there's a logic there that they should control their own system. On the other hand, copyright owners know better what they have or have not licensed, what they own. And so they have that amount of information. This is again why the cooperation is what's necessary. If the platforms and the copyright owners are willing to cooperate and the copyright owners provide that information to the platforms, then the platforms know, all right, these are the works owned by this creator. These are the works owned by that creator. And they can use the technology, including Audible Magic and others, that will allow those works not to be infringed nearly as much as they are. For all the sloganeering, the reality betrays how untrue those slogans are. So I'll take the Content ID system, which is currently used on YouTube and has been for some time now as both a filtering tool and a monetization tool. And if you're a creator, you can, and you're allowed to sign up for Content ID, because not everyone is allowed to. But for those who do, just like Vance was describing with his technology, you can calibrate exactly how much use you will allow, and you can monetize that, and you can block uses over that threshold. That's exactly what it should work like. Now, Content ID isn't perfect for a few reasons. One, not everyone gets access to it. And if you don't have access to it, you're stuck with the ineffective notice and takedown system in current law. And so even the other big weakness of Content ID is that the reports from, for example, songwriters about the royalty percentages that are paid out to the copyright owner is that YouTube pays by far the lowest rates of any music service. And so wonder, well, why is that? And it goes back to the law favoring one business model over another and putting a thumb on the scale of negotiations. If you're a copyright owner and you sit down with a representative from YouTube, you say, okay, I'd like to sign up for Content ID. Well, if they say no, you're just done. Even if they say yes, you're agreeing to accept very far below market rate licensing in order to get the tools that Content ID provides in terms of filtering and blocking. Because you know that you're basically going to either take those crumbs or you're going to get nothing. And your work is still going to be on YouTube, because notice and takedown will not keep your copyrighted work off YouTube. And YouTube will still enjoy the safe harbors, so you can't sue them, even if you had the wherewithal to go against such a large corporation. So that's the core of the problem here. The law is tilting the market away from cooperation and balance, and we need to bring it back into line.
Yeah. The other thing I'd raise, and this might tee up Vance actually, is the other, not only does the law tilt the bargaining power, but the law is also based on the set of technological tools that were available when the law was written in the late 90s. The technologies have evolved, in incredible amounts to where we can now do things that just weren't even imaginable when the law was written. Shouldn't we incorporate those new technological capabilities into how we structure this balance? Vance, I don't know if you know anything about how the technologies have evolved over the last 20 years, but
well, Audible Magic is 21 years old. So we've started from the beginning with physical piracy to peer-to-peer piracy to now, user-generated and social media. But getting back, because there is a good topic there, Mike, about the law and technology. But going back to the original question, Devlin, was, is this an either or? Is the platform should be the police or the rights holders? And I think the consensus here is, first, it's not either or, that both sides all have to contribute and play a role in making the system work. But I would like to make a other comment about this, is that there is a lot of friction in this system. There's a lot of friction, so it doesn't make it a very efficient market for being able to have platforms licensed, and for rights holders to get platforms licensed. there's just a lot of things, if for anybody aware of music licensing, that just cause a lot of big obstacles to making that really clean and smooth. I don't completely disagree with the idea that the incentives may not be aligned correctly, but I also may disagree if the blanket statement that most platforms are trying to skirt the law and trying to do the wrong thing overall. I think most of our customers are trying to do the right thing. But I don't also disagree that there are a lot of players out there that are clearly taking advantage of the way the law is. But I think as a group, we should recognize that there are platforms trying to be good citizens as well.
Oh, absolutely, Vance. And I figure if they're hiring you, they're probably one of the good guys, right? Or else why would they want to filter anything if they're an obvious pirate site? So we recently had a report from the U.S. Copyright Office on the efficacy of Section 512. And I think all of you were involved in it somehow. I know, Mike, I definitely saw your work in the footnotes. And Vance, I know Audible Magic filed comments. I in some other copyright scholars filed comments too. And our main gripe was about the red flag knowledge standards. And when does a service provider have knowledge such that they have to act? And so the Copyright Office actually did adopt our position on red flag knowledge, but the Copyright Office adopted a wait and see attitude on filtering and site blocking. They basically punted the issue and said, these are new things. We don't have enough information to know how well they work. And so the office didn't exactly say Congress should move ahead and enact these things into law. And so I was wondering, what's your take on that? Was the office wrong? Do we have enough information to move forward with this legally? It's a loaded question, I know.
Well, I'll jump in. I mean, look, the answer is yes, the office was wrong. Yes, there's enough information to move forward confidently. Dozens of other countries around the world have implemented various forms of site blocking. Site blocking, as certainly as I conceive of it, and I think in most, if not all of those countries, is done through a fair judicial process. It is viewpoint neutral, and it is based on the standards that are not only in the law, but have been agreed to globally in the World Trade Organization and the World Intellectual Property Organization. So let's face it, there were politics involved. When this did come up in the United States a little over a decade ago, it became very political. There were all sorts of accusations that were made and predictions that just had no basis in reality. And now we know they're false. We've seen it implemented over and over and over in one country after another, countries like the UK, where society is not all that different from US society. And there's no reason to continue to accept that these ridiculous predictions have any basis in reality. It's time to start talking seriously about getting this done, because, and the other key point here is, this is not site blocking of some borderline close call, and every law has its close calls and gray areas, and copyright is no exception. But this particular proposal is designed to get at clear-cut cases, sites dedicated to infringement. And these are sites specifically, again, it's important to focus on, not based in the United States. If they're based in the US, our courts have jurisdiction. Our law can be applied. Our law enforcement agencies can handle it on their own. When these sites exist outside the United States, as is unfortunately fairly common, the pirates pick locations where they know the law is weak, the enforcement is weak, and they hide behind proxies and various technological tools that prevent people from even identifying who they are, much less where they are, much less effectively enforcing against them. So site blocking, if the best answer would be the whole world has an effective and fair copyright system, and we can get justice anywhere in the world. Until we get there, site blocking protects US consumers and US businesses from these foreign-based pirates, and it's done through a fair judicial process.
All right. Yeah, thanks, Steve. And so, in what you mentioned, I think is really important, and we talked about this a little bit earlier, but a lot of the complaints about filtering and site blocking is that they're talking past each other, right? So I think copyright owners are thinking about wholesale piracy, entire movies, entire songs on the internet, right? And that's what they're worried about. But then other people say these technologies threaten civil liberties, particularly fair use, which is arguably protected by the First Amendment. And so they say, well, I'm uploading a meme or something that just uses part of a work. And so they see this as an attack on their civil liberties. At the same time, a lot of these same critics say, well, filtering and site blocking just doesn't work. It'll be ineffective. So apparently it's really effective at harming civil liberties, but terrible at stopping piracy at the same time. And so I'm wondering, what do we do about that? And how do we talk about the same thing? Are we talking about entire works or snippets of works? And how can filtering and site blocking take account of the fact that people should be able to make fair use of a work?
Well, I guess I'll jump in again. And I want to distinguish between filtering and site blocking because they're two very different tools. So filtering is a platform using technology to control what is and is not available on its network. That is done commonly today. The platform can decide exactly how it wants to do that. The platform can do that in cooperation with copyright owners or other interested parties in other contexts, because this is applied in lots of contexts, not just copyright. And we get some objections from people, notwithstanding the reality that it's already happening. Some people say, like you say, Devlin, well, it's going to overblock, it's going to be over this, over that. Well, there are going to be close calls, but that hasn't stopped anybody from using filtering in lots of other contexts with close calls. And a great example, I think, are spam filters. We're all very, very familiar with spam filters. And we're very, very happy to have them, even though they sometimes impinge on protected speech. We've all had perfectly legitimate emails from business associates, friends, land in a spam file instead of in the regular inbox. Both we and the technology companies have figured out ways to make that work. Is it 100% perfect, always accurate, never wrong? No. Does that mean it's a bad system? Don't try? Of course not. Now let me turn briefly to site blocking, which again is a different tool. This is about denying foreign-based pirates access to the US market. And again, based on sites that are dedicated to infringing activity. That's what they're there to do. There's not close calls there. This is blatant piracy. The claim, when you unpack what the people who tried to argue against that said, the argument boils down to, well, in order to continue to get access to pirated works, massive numbers of Americans would leave the secure DNS system for rogue servers where they would be exposed to malware and those sorts of things. And it assumed both a tremendous amount of risk-taking on the part of American consumers to get illegal content, or content illegally. And two, it assumed a great deal of sophistication on their part to be able to achieve that. And it was far-fetched when it was a prediction. Now we know for a fact it's false, because Mike's paper shows us that in the UK, where this has been done, that's not what happened. What happened is most people went to legal alternatives. Are there some hardcore pirates who will go that route? Sure. There's always going to be that hardcore few. None of these tools are perfect. None of them are going to reduce piracy to zero. That has never been a realistic goal. That has never been the goal. The goal is to reduce it through a reasonable and cooperative system to a level that maximizes creative and business output for the benefit of both American businesses and American consumers.
Let me add on to what Steve's talked about from a filtering perspective. So I was saying that we check 5 billion, lookups every month. So that gives you some sample size to say, are you going to have this problem with overblocking? Most of our customers not only use us, but then they've implemented dispute redress mechanisms to try to ensure that if they think there's something in error, that they have a vehicle to express that concern. And by the way, when those things happen, you can bet those platforms will talk to us about what happened here and why was this maybe falsely identified. Well, we get those rarely in a year of transactions. And in most cases, when there'd be a complaint, a counterclaim, and it ended up being not a technology kind of problem. And so to add on to support your comment, Steve, on the filtering side, in most cases with billions of transactions, the technology, the way we've designed it, has been meets, I think, the spec of not trying to overblock, but from a majority of cases, do the right thing. Now, I'm not going to say every technology is like that, but I think there are technologies that do exist that can meet those requirements.
And we can use, I think Vance's point is a great one, right? Is the technologies improve over time, and what Moore's law tells us is they improve exponentially over time. Why not get them out there and let technology do what it does? Do a better job of working over time as we learn more about it and adapt. I think the redress issue is also absolutely vital. If we make a mistake, let's have an open and transparent process to correct that mistake, learn from it, move forward.
Great, thanks guys. So we're getting close to the end of our time. Vance, I wanted to ask you a question in particular, because I know you have some experience with this, but could you tell us a little bit about what's going on in Europe with Article 17 of the Copyright Directive and any other developments there that you might be aware of?
Okay, I'll just do a quick refresh for everybody what Article 17. I think in the European Union, a lot of this conversation has gone up. The issue was there balance between the rights holders and the platforms? What Article 17 of the Copyright Directive was basically a clarification of existing copyright law. The belief at the time was that the existing copyright law really did not contemplate these platforms that indexed and allow searching of content. Originally, the copyright law we're thinking of people like the ISPs and to provide copyright protection. So what they clarified was they identified a class of platforms that they called, I think, online content, OCSSPs, well, I can't even remember what it means, but they were basically digital platforms. And what the law basically tried to do was restore balance and specify obligations. And the obligations on the platforms were, number one, prevent the availability of unauthorized copyrighted works. Number two was that they had to comply with notice and takedown, including a stay down capability. So a copyright holder noticed that content had to stay down and couldn't reappear, which I think is a common complaint of the rights holders in the US regime. And then the third was that the platforms had to make best efforts to obtain licensing of the content. The obligation, if they met those requirements, effectively a new safe harbor was created to protect those new platforms. The obligation that was placed on the rights holders was to provide necessary and relevant information to prevent the unauthorized distribution. So both sides were obligated to do something. They didn't specify a technology specifically per se that had to be implemented, but frankly, at large scale, the technology was the only way to try to address the law and to comply with the law. I do think it was there was this delicate balance that had to be made, and I'm always concerned, even though I'm a technology guy, I'm concerned about legislating specific technologies or technological approaches. And so I think the European law tried to address that, and not specifically, but generally. And so I think the law is in the direction of what Steve and Mike are advocating a little more, and it's a little early. And I think we'll wait to see in the next year or two, what actually happens.
Yeah, thank you for that, Vance. That was a great explanation. And it is interesting that, what maybe we're taking a wait and see position right now, but we can see what develops in the EU and how these things are implemented. And apparently different nations can implement it slightly differently and still comply with the directive. And it will be very interesting to see what the fallout is from all of that. And so it looks like we're coming up on the end of our time. And so I wanted to give you guys a chance if you wanted to have any closing thoughts to share with us before we sign out at the end here.
I guess I could start since I'm unmuted. I do believe that others have mentioned, I think that the place we all want to get to is we want to get to a place where rights holders and platforms and consumers can all benefit from the internet and digital media, where consumers have access to media, where rights holders get paid for the use of their media, and then platforms can, be able to build their business too and have that all work. I do think that it is a path to get there, and which requires both potentially legislative policy as well as technological and business changes. But I think we're starting to head in the right direction, and I'm really anxious to see how it unfolds over the next few years.
I can jump in and just put my empirical hat back on and say, I think the other thing I'd love to see lawmakers take into account is the actual empirical evidence. We now have a great deal of rigorous studies that show that there's harm here, both to producers and consumers, and evidence that shows that we can address that harm through a set of reasonable legislative measures that can improve outcomes for society. That ought to be exactly what our lawmakers should be in favor of.
So notwithstanding the polemics and sloganeering that we get from some quarters in the public policy debates, the business reality is that internet platforms and copyright industries are mutually beneficial. They are symbiotic. The copyright industries provide the sort of content that draw people to the platforms, and the platforms provide the technology and reach for the content industries to serve the customers they want to serve. That cooperative arrangement is being hampered by the current state of the law. And those who are okay with that try and describe this situation as technology versus copyright, when it is exactly the opposite. When we recognize that, and we recognize that copyright industries are a $1.3 trillion part of the US economy, and that they are not being appropriately handled in the current state of the law, and that is getting in the way of cooperation, then we can move forward.
All right, I like it. So I think in summary, we have the technology works, we have the empirical data, the data shows that it works, and what we need is for the law to catch up, right? So the DMCA is over 20 years old, and so much has happened since I set up my first GeoCities website way back when. So I just wanted to thank all three of you for taking an hour out of your very busy days, I'm sure, and joining us for this panel discussion. I think it's been a wonderful talk, and I really appreciate all three of you, Vance, Mike, and Steve, for joining us today. And I hope you enjoyed it as well.
Thank you.